Mayor, do you mind if I?
Please do.
I just wanted to cite a few authorities because they're tucked in the resolution, but if the public didn't get a chance to read the resolution, I think it's important to kind of put this more in context. So clearly the federal government's responsibility is immigration enforcement. And what we saw in 2017 or 18, I forget, was a sort of a clash between California's new sanctuary state law and the federal government, because the federal government was basically saying, and this is the Jeff Sessions lawsuit, that the federal government had a right to essentially commandeer local resources, state and local resources, against their will to effectuate federal programs, including immigration enforcement. And the court struck that down and said, no, pursuant to the 10th Amendment, the federal government can't commandeer state and local officials, law enforcement officials, against their will to effectuate federal law programs. However, the sanctuary state law actually goes further, and it impedes or interferes with local law enforcement officials' ability really to comply with federal law where they're required to, and it prevents local agencies from voluntarily complying with federal agencies. So where the 10th Amendment bars the federal government from commandeering state and local law enforcement agents against their will, there really should be nothing that stands in the way from state and local officials from voluntarily cooperating if they think that provides the best law enforcement practices for their area. But more than that, the sanctuary state law literally interferes with our ability, all of our ability, including your ability, to comply with federal law. And these are federal laws that present federal crimes. I'll give you some examples. So according to the US Department of Justice, and I pulled this from the website today, I've done research before, but I literally wanted to be able to say I pulled it from the Department of Justice website. And this was up there when Biden was in office, President Biden was in office. So harboring, the US Department of Justice website literally says harboring. Section 1324 of that's Title 8, sub A1A3 makes it a federal crime for any person who, knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law, conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shield from detection the alien in any place, including any building, which would include a jail cell or a prison, or any means of transportation. That's a federal crime statute right there. And we're obligated to not commit federal crimes. The sanctuary state law in California prevents you, and really causes you to commit a federal crime. Encouraging and inducing, section 1324A1A4 makes it a federal crime for any person who encourages or induces an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of federal law. There's also a federal crime for aiding and abetting an illegal immigrant under section 1324A1A5. And then if we jump to 1324A1A, it makes it a federal crime for any person or other entity to hire, recruit, or refer for a fee for employment in the United States an alien, knowing the alien is an unauthorized alien as defined under section 1324. So even hiring, and we know that the state and like Los Angeles, the city of Los Angeles has a program where they proactively seek to hire illegal immigrants, and that's a violation of federal immigration law. Finally, I'll jump to Title 8 USC, section 1373, that says, excuse me, notwithstanding any other provision of federal, state, or local law, a federal, state, or local government entity or official may not prohibit or in any way restrict any government entity or other official from sending to or receiving from the Immigration and Naturalization Service information regarding the citizenship or immigration status, lawful or unlawful, of any individual. So that literally says, basically, you can't have a sanctuary state law because the state can't tell local agents that they can't communicate with federal agents. That's a crime under the Title VIII. And just a couple other pieces of information that I think are noteworthy. So I know Attorney General Bonta is making a lot of strong statements about the sanctuary state law, trying to defend it, and he's coordinating with Newsom to try to Trump-proof California. But his very predecessors, so the California Attorney Generals who preceded him in office, published opinions on sanctuary policy. In 1992, the California Attorney General published an opinion that said, due to the supremacy clause of the United States Constitution, a city may not prohibit its officers and employees from cooperating in their official capacities with immigration and naturalization services, investigations, detention, or arrest procedures relating to alleged violations of the civil provisions of the federal immigration laws. So that's the California General. And nothing has changed, as far as I know, with the United States Supremacy Clause and Title VIII, because it's specifically referring to Title VIII USC Section 1324. The California Attorney General literally analyzed the very same section we're invoking tonight, Title VIII USC Section 1324, and said that that essentially preempts any sanctuary policy, state or local. The Court of Appeal in California has said, where otherwise warranted investigation by local officers leads to evidence of a federal, civil, or criminal violation, the local authority has the right to exchange information with federal authorities. To deny such an exchange is not reasonable and rewards those federal violators fortunate enough to be arrested by local rather than federal officials. And then finally, the California Attorney General also stated that sanctuary ordinances concern a subject matter, immigration, wherein federal power to regulate is exclusive. And that comes from the US Supreme Court in the D. Canas case v. Bica, 1975 case, that's 424 US 351, US Supreme Court case. Federal preemption occurs when the local enactment stands, this quote, stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. Quote, a direct conflict with a federal or state statute or regulation presents a separate and distinct basis for the preemption of the sanctuary ordinance. And that's also the California Attorney General. So every single authority that we looked for, whether it's California Attorney General opinions that were published in the past, Court of Appeal opinions, US Supreme Court opinions, and federal immigration law, all comes down on the side of our local authorities being able to coordinate and cooperate with the federal government to enforce the federal immigration statutes. And every one of those legal authorities stacks against the California sanctuary state law. Thank you.
Chad.